Hello, everybody. My name is Ian Adel, and today we are going to be breaking down Chapter 1, which is basically just a brief overview of what criminal law is, what's really substantive law. We're not really covering the procedural nature of the law for this class, but we're covering more of the substantive rationale about how the law develops, what makes laws fair, um, how should laws exist in our society. That's what we were referring to when we say substantive law. Now, the first thing we need to look at is what are categories of law? Okay, and there's generally five in our society. The first one is crime. A crime occurs when an individual commits a violation of some statute, administrative regulation. They can violate their probation, their conditional discharge, something where the state is attaching their power to it. Not in all contexts, because you can still violate something that the state offers and it could still be civilly too, like under the EPA. So be aware of that too. That's a trick that professor can throw on a test. So just be aware that just because a government's involved doesn't necessarily mean that there's a crime occurring. But most of the times it does. A non-criminal wrong is something that is designed for the purposes of compensation. If an individual commits a violation of an act, but that act is not criminal, they have a duty of care in society to refrain from such an act, such as pulling a chair from under a person when they're about ready to sit. That justifies this notion of non-criminal wrongs. It's the purposes of compensation that is solely rooted and solidified in non-criminal tort allegations, because the purpose of a tort is to compensate the plaintiff because the tortfeasor did something that was going to harm the plaintiff. In some cases, if it's so odious, we are going to levy punitive damages. But punitive damages is not a way of society punishing an individual. It's a way to specifically deter a potential tortfeasor from committing that same tort allegation. A regulation is something that the government doesn't really criminalize, but it still discourages it. Like, for example, like smoking, for example. The heavy cigarette taxes in 1996 are perfect examples of a regulation. Regulations can also be in the form of administrative regulations as well, making sure that you go through certain standard operating procedures before you do something. Something can be unlawful but not illegal. You see what I'm saying? So a regulation, if you don't follow specific regulations, you're committing an unlawful act. Doesn't mean an illegal act, it's just unlawful. You see the difference there? So that's important to recognize when we're talking about regulation versus crime. A license now. A driver's license is obviously not illegal. A driver's license you have to pay a price for. You have to complete a test to receive that license because it deals with police power. There's some substantive moral obligations that people have that need to be prioritized. But generally speaking, the state says we have a compelling interest here to issue a driver's license because we don't want any person going out on the street not knowing laws and causing accidents, committing crimes, violating society's expectations, and basically their moral principles on how to drive in accordance with traffic laws. And the fifth and final example discusses lawful behavior. Lawful behavior is individual conscience and or social behavior that should be condemned. Or there should be no legal consequences at all. In society, the behavior should simply either just be discouraged by common people, or the behavior should be totally legalized. We can think of thousands of examples of this. So I really want you to think about the notion of criminal law and the elements of how it's categorized. The categories overview of what makes something criminal, what doesn't make it criminal, what makes it criminal, what makes it civil. Okay? Remember, criminal law focuses on society, you know what I'm saying, in general. The government's getting involved and you can be incarcerated. Civil law, on the other hand, is focusing on compensation. It's about compensating the individual involved because that individual warrants a form of compensation because an injustice took place. Now, based on criminal law and society, we have the social reality of U.S. criminal law, where we have two general categories. We have the mala in se category, the mala prohibita category. The mala in se category encompasses things like murder, things like rape, things like arson, things like robbery. Those are the mala in se offenses. These are your premeditated offenses that are based on concurrence, based on the agreement between actus reus and mens rea. Then you have the mala prohibita offenses, and these are your misdemeanors, your violations, your strict liability offenses, etc. These are only criminal because they are explained by a statute, not because they go back to William Blackstone's time and haven't been changed that often. The criminal law imagination focuses on this interdisciplinary law of the study of criminology, where we are combining history, sociology, philosophy, criminal law, just any sort of social science that you can think of that you study in your everyday college. And we are going to ask ourselves, what should we impose on the moral world? And the criminal law imagination is what sets us up for our punishment imagination. See how we just went from substantive to procedural? We went from substantive, being that we're going to take all these different studies, we're going to take all these different interdisciplinary fields, we're going to sit them down and we're going to discuss and say, what should our society follow and what should its moral desires be? What duties should it define? What substantive law should it explain and express? And then we are going to explain to ourselves, what should the punishment be? What should the ramifications be for such an offense in our society? And we are now going to punish those individuals accordingly for violating those offenses. Now we have core felonies, okay? Generally speaking, we have two main areas of core felonies. The two main areas of core felonies that we have are, number one, felonies against persons, which include murder, which include manslaughter, rape, kidnapping, and robbery. And then we have felonies against property, which include felony theft, robbery, arson, burglary. Now, you might have heard me say robbery twice. Why? Robbery is both a violent crime and property crime. Because with robbery, you are putting an individual person in danger, and you are also stealing their property in the process. So it is both violent and property crime. Harsh punishment is the punishment that is awarded for the core felonies, because harsh punishment is an area where our given society punishes an individual for a year or more in prison based on the core felony notion. Now we also have the social reality of core felonies in the United States, where there are far fewer core offenses and far fewer people committing them than compared to the rest of criminal law. Meaning that we have more drug crimes, we have more property crimes, we have more crimes of other natures that are not under the violent category. They are merely under a property or a drug category or a procedural technicality violations, I call them. Those are your VOPs and your post conditionals, et cetera, et cetera. Then we have, they're generally ancient. Murder is one of the ancient cases that goes back to the Queens versus Stevens and Dudley. And it goes back even further than that. That was the case that determined the defenses to the Queen versus Stevens and Dudley. Most of the elements are remarkably stable as well. Most of the elements do not change as a result of core felonies. Why is that? Because core felonies have such a high burden of proof, a high requirement for the requisite mental state, and core felonies, generally speaking, don't need to change the elements because it's not one of those crimes that is very defeasible and should or shouldn't be a law, or the statute might change over time because the government finds different areas where things can be lawful, like the difference between marijuana being legalized, marijuana being decriminalized, and things of that nature. Then we have to take a look at how the list has not grown since Blackstone's day either. Because if the list grown since Blackstone's day, then we're going to be constantly updating the criminal law imagination and the criminal law punishment imagination. And there's going to get to a point where we're going to have way too many laws. We're going to have way too many changes to the necessary core felonies. Core felonies need to remain stable. They need to be felonies that are defined in society so that everybody knows what they are, so that people do not commit them. Misdemeanors, on the other hand, as well as violations, are not something that is as major as felonies. So the defeasibility of misdemeanors and violations and strict liability offenses can be of such a great magnitude compared to issues of core felonies. And what I mean by this is misdemeanors, for example, like harassment second degree in the state of New York. Yeah, when I was in the public defender's office, I saw this case all the time, okay? Harassment second in the state of New York is a violation, but it's very defeasible, meaning that you don't need to prove criminal intent for it. You just need to prove that the act occurred. It's strict liability. So what's really important about that harassment second is that it gives the prosecution a lot of leeway with how they can prosecute the case. And it also doesn't really award a great punishment. The worst you could get with that punishment is not even 1 year in jail. The most I've ever saw for that is a fine or community service of such nature. I haven't even seen any jail time for a harassment second degree in New York State. I mean, it's possible. I think it's about 15 days. Don't mark me on that, but I do believe it's 15 days. So, I hope that helps with the core felony concept now. Now we have to take a look at police power in the state. Now, this is a big one. So remember, laws happen not just at the federal, not just at the state levels. They happen at federal, state, county, and local under the principles of federalism. Police powers also allow the formation of executive, legislative, judiciary's power, including uniformed police officers to carry out and enforce the criminal law in general. Then we also have preamble protections. And the preamble is very important in the Constitution. If you don't know what the preamble is, this is what it is. Now listen up. We, the people of the United States, in order to perform a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty. So if you're asked, what's the purpose of the law, or what's the purpose of criminal law of such an extent, those are your answers. It's also meant to serve the people too. So if you see any question about what's the purpose of the law, or what's the purpose of criminal law, remember, establishing domestic tranquility, establishing justice, establishing general welfare, establishing the common defense system. Those are very important characteristics. And don't forget about this one, securing the blessings of liberty. If I was going through and I was grading a quiz and I asked you, what does the preamble protect? And you don't include those elements, you're going to lose points because those elements are what the framers thought were the most important when protecting us against government intervention, when it says securing the blessings of liberties to ourselves. And it is also important about what the government thinks should be punished, what the government thinks should be the purpose and the formation and the amalgamation components of the entire federal government system and the purposes of state government systems as well. Otherwise, they would not have included restrictions on state power in Article 1, Section 10 as well. And Section 9. Blackstone defined police power as individuals in the community being bound to conform their general behavior to the rules of propriety, good neighborhood, good manners, and decency. Remember, police power is about promoting domestic tranquility. So, us in society, we are members of society in a pluralistic society under the notion of federalism, under the division of shared governance and shared powers, where we do not want to give too much power to a government, but we need to give power to a government through the notion of a social contract in order to look out for our own interests. And the only way that can happen is if there is governmental oversight into actions that should be deemed illegal. And that is what the important power of police power is. And this goes back to the American Revolution, where individuals were not just trying to rebel politically. If you look at the entire notion of constitutions from the states after the American Revolution, they allowed the common law. If they wanted to get rid of Great Britain's political system, they would have not allowed the common law. They liked the legal system of Britain. That was a social revolution in order to remove the elites from the elite colonial rulers from the colonies during this time, and allow those independent colonies to become states where they can look out for their people and their people's interests. That's what the idea of the revolution was about, not about the idea of abolishing a legal system. And we saw in George Washington's Whiskey Rebellion that same exact notion. Also be aware that the American Revolution shifted America from this notion of anarchy to the notion of a commonwealth, to the notion where individuals are going to come together, like in the state of Pennsylvania. And I say Pennsylvania for a reason, because this is the most democratic state in the Union. Pennsylvania loves democracy. Democracy is rooted in Philadelphia. That was the home of Ben Franklin. That is what's very important about the revolution, is that it shaped this notion that we're no longer going to be tyrannical, we're no longer going to be libertarian in our society. We are now going to shift away from that, and we are going to entrust the government with power to such a magnitude as the people deem fit and as society thinks is morally conscious, in order to protect our society from wrongdoing. Jacob Wheeler also held this. He separated the incidents that should be addressed between these following categories: the foolish, the rash, the wicked, and binding equal justice. Okay? Those four are important to discuss. So let's discuss what those four categories are that Jacob Wheeler is discussing. The foolish are people that don't know they're breaking the law. Okay? They are what we would call following ignorance of the law. And they're trying to claim that they made a mistake. They didn't know that the law they broke was wrong. Generally speaking, the court does not accept this. But there are exceptions to this, and we'll discuss that in a later video. But what's important about this is our society should not punish, someone who acted foolishly compared to someone who acted rashly or wickedly. You see what I'm saying? Rash is something that you still committed the act. You still acted in I would call a wicked spirit behind the act, I should say. But the difference is there's several factors that should bump it down from this purposely and this evil motive intent behind it. Like, for example, if you're young and you commit the crime, should you really spend your entire life in the criminal justice system for a mistake you made when you were 18 or 19 years old? The answer to that question is no. Now, wickedly, on the other hand, is something that you should spend your entire life in jail for if it's for something like first-degree murder. Or you should spend a really long time in jail for something like rape. You see what I'm saying? So we need to have a society where we're not only classifying laws based on what type of law they are necessarily, but we are also distinguishing between the most morally desirable people being punished and the least desirable people being punished. And that is what the notion of justice and culpability are about. And that falls under the police powers doctrine. So just remember that as well. Non-criminal wrongs and criminal wrongs. So we are now going to discuss a little more in depth about what criminal law is and non-criminal wrongs. Well, first of all, criminal law is very harsh under many circumstances. The ideas of the principles of proportionality and the principles of parsimony are very heavily discussed by judges at the appellate and apex level courts, to the extent that individualized crimes most of the time are out of proportion, especially in southern states like Texas, for example, Oklahoma, Mississippi, where they want to solely just restrict individualized autonomy and expand and aggrandize their state power because they want to make sure that all crime is punished equally and that if you commit the crime, you're going to do the time. While here in New York State, for example, or in a state like Colorado or New Mexico, for example, is going to be a state that is a lot less stringent on crime and more about the issue of crime prevention. So don't be so retributive. Embrace more of a utilitarian approach, for example, where we're going to take a look at should deterrence apply here, or should incapacitation apply here, or should retribution apply here. Anything that is needed to ensure that society is going to have crime prevention. That's the purpose of utilitarianism. Retribution, on the other hand, is not based on that notion. It's solely based on just punishment. If you're culpable, you're going to do the time. No matter what, you are going to do the time. So you got to know the difference between those two theories of punishment. I do argue one is better than the other. I'm not going to say. But I think you can figure out which one's better than the other one. Torts. These are private wrongs, okay? Private wrongs are where you can sue a party. Criminal law deals with society in general again. We already discussed that. Compensatory and punitive damages now. Compensatory damages are about compensation. These are very large damages in terms of like a material damage in particular, meant to give money to plaintiffs for their actual injuries. Punitive damages are only meant to deter future tortfeasors if those crimes were so bad that we need to condemn them in society. The power of law also backs up these rules, so know that as well. That should not be something that's difficult. Classifications of crime. So we have mala in se offenses, mala prohibita offenses. Mala in se are like the evil intent offenses. Mala prohibita offenses are the offenses that are um, strictly based on strict liability or only actus reus, and they are criminalized because of a statute. Now you need to know the difference between a felony and a misdemeanor. Really easy. Felony, you go to prison greater than 1 year. Okay? All you need to know. Misdemeanor, you go to the county jail. It's equal to 1 year or less. In cases of a leap year, now this is important, 366 days. If you're not in a leap year and you're sentenced to 366 days, you go to prison. It's a Class C felony. But if you are in a leap year and it's for a misdemeanor, you can go to the county jail for 366 days. So be aware of that too. Because that's a question that might, maybe not, be asked. The classification depends on possible punishment, not actual punishment. So you can't merely be found guilty of a misdemeanor instead of a felony because you were sentenced to 6 months in jail rather than 2 years in prison. You see what I'm saying? It's based on possible punishment. So because you're convicted, the judge has to follow their sentencing guidelines, okay? And if the judge follows their sentencing guidelines, then at the minimum, you can be sentenced to X, and at the maximum, you can be sentenced to Y. Now, if the X for the lower bound is greater than 1 year or less than 1 year, that's where this notion can come into whether or not is this really felony, is this really misdemeanor. But Commonwealth versus Rhodes said, you're convicted based on what the law defines you as. So you're being convicted, in essence, you're being sentenced based on your criminal conviction status of the substantive law you broke, not based on the notion of what punishment, what was the actual punishment you received. No, it's based on what punishment could have you received. Okay, the sources of criminal law. You gotta know what the sources of criminal law are. Be aware that laws come in many different forms. You have 4 different forms of the law. The U.S. Constitution, okay, that's the supreme law of the land. Then you have state constitutions. That's the second one. Then you have, after that, statutory law at the federal level, which is called the U.S. Code, the state level, which are state criminal codes, the county/local level, which are municipal codes, and these have to be codified in statutes. Now you have administrative law. Administrative law can define crimes and can also define how to respond to crimes based on the substantive law enacted by the legislature. And that happens at the federal, state, county, and local level. And this is based on administrative regulatory power, also known as adjudication, but when you get to law school, you'll figure that out. Then we have case law. Case law that's promulgated by courts at the federal, state, county, and local level. Now we have prosecutors and criminal law enforcement agencies which have this discretionary power. It's bureaucratic power in essence, but it's not so much of administrative law defining what type of law we're referring to. This is more of a law that's actually being implemented in order to make sure that individuals are not breaking the law, and if they do break the law, they should be punished. This is about the idea of serving justice. The key notion of being a prosecutor and being a law enforcement agency is not to criminalize pure status, and it is also not to be vindictive or retributive in your enforcement, but to serve the good of society. That is the key importance of being a good and fair prosecutor. The Model Penal Code. Now, this is important. The Model Penal Code, so we have 2 different types of law. We have the common law, obviously, that developed since the inception of our republic through the laws of England. And then we have the Model Penal Code, okay? Criminal liability is conduct that unjustifiably inexcusably inflicts and threatens substantial harm to individual and public interests. You gotta memorize those 9 key phrases. There's no way around it. So let me break those individual key phrases down. So conduct, you have to be criminalized based on a conduct crime at the minimum. So there's different types of crimes. You have bad result crimes, you have conduct crimes. Conduct crimes talk about your actus reus, your mens rea, and your concurrence in the agreement between those. Okay? So your thoughts have to cross the manifest of criminality. They have to then agree to a concurrence notion, which is based on a mental state, which then triggers a criminal voluntary act, not based on cases of automatism. That is what defines criminal law. Now, that's what the conduct part is now. Now it has to be unjustifiable and inexcusable. You can complete an act that has essentially all those requirements or an amalgamation of some of those requirements. But if there is a relevant affirmative defense to it, you didn't commit a voluntary act. You see what I'm saying? So even if you had a criminal mind, even if what you did was illegal, like you stabbed the guy who was coming at you because he was going to stab you, still, you know what I'm saying? It's still unlawful, but you didn't commit a voluntary act. You weren't doing it out of your own conscious nature. You're doing it because it was a matter of life or death situation. So that doesn't rise to a level of a criminal offense. Inflicts and threatens substantial harm. I think that's pretty self-evident. Your act needs to inflict a bodily injury of some type. Someone needs to get injured in the process. There needs to be a victim to a certain crime, whether that's the community at large, whether that's an individual person. That is what element 3 is addressing. 4, to individual or public interests. Again, same thing. This also can be confused with tort law too, because tort law has these elements in essence as well. But the difference is that with criminal law, remember this focuses on society at large. So when you do harm to an individual, you're hurting a piece of the puzzle of society. In tort law, you're just hurting a person. You see the difference? So even though these overlap between criminal law and between tort law, criminal law has to go above non-criminal legal sanctions. That's the key difference to determine between criminal law and civil law. The criminal law system in our federal system based on the 10th Amendment and our system of police power has 52 different criminal jurisdictions, 50 in all 50 states, 1 in D.C., and 1 at the federal level. Be aware of that. That's a testable question. This is important to note as well. 52 criminal code laws vary based on jurisdiction, and they establish general principles for the territory and people therein. Not every territory needs the same laws, for example. Some territories are more urban than others. Some territories are more rural than others. Some territories need to address environment more than others. Some territories need to address the UCC more than others. That depends too. Some territories need to enforce the interstate commerce provisions that are set out because cross-cutting requirements and crossover sanctions can heavily restrict them. So that's important to note as well. So remember, when you cross between different boundaries and different state lines, general principles and the specific elements for those crimes can change. The defenses to those can change. The punishment differs between those different jurisdictions. And there is no cut and dry code 100% in every single state. There's like this defeasible basis. There's this different system in each of these 52 jurisdictions that you have to be aware about as well. Diversity among the code makes clear so that there's no single U.S. criminal code. There is a criminal code at the federal level, obviously, but there are other laws as well. It's not merely only law at the federal level. It's at the federal, the state, the county, the local level. Okay, so criminal law in society. We're going to be taking a look more at like concentrated disadvantage, the issues with intersectionality, the issues with poverty, unemployment, bad schools, high crimes, single or no parent families, little to no social agency support, mostly young, poorly educated, little to no training or work experience. Um, but this is the key right here. And this is the really, really sad part about our criminal justice system, unfortunately. There is an overrepresentation of minorities that are in jail and in prison compared to whites. This is because starting at the Reagan administration, I mean, even before that, under Richard Nixon, the war on drugs was starting to take place. And the war on drugs all dealt with labeling theory and dealt with the victim overlap theory to the extent where minorities were becoming stereotyped and they were starting to be arrested for literally no plausible reason. It was just this stereotype mentality. And then here comes Terry v. Ohio, pat down search. Oh, we're going to allow police officers who already have bias in their minds and are already very biased with the way they think to go around and conduct pat down searches. So that's ridiculous. If you commit a crime, then you should be punished for the crime accordingly. You shouldn't give police officers the chance to start defining status and harming individuals. But then here comes the other side of that argument. What happens when we are referring to an act of danger, for example, and there's an imminent danger in society? One is in the process of committing a crime, or one is armed and dangerous. What should you do then? So that's what the Supreme Court had to address in Terry. But it still is contributing to the notion of the overrepresentation of minorities in jail and prison compared to whites. And I really hope that our society can fix this issue and reduce the disparity, and to make sure that people are going to prison based on the acts they commit, not, and I repeat again, not based on status. The era of mass imprisonment and criminal punishment started to rise in the 1960s because of urban riots. After 40 years of rising incarceration rates, the rate for violent crime rose, fell again, and it drastically fell in the 1990s. It's really important to note that a lot of these laws that have been enacted in regards to parole, in regards to substantive and procedural law, have very targeted, concentrated, disadvantaged communities, specifically poor communities and poor neighborhoods. This mass imprisonment has caused unwanted social costs that outweigh its crime reduction benefits due to what is called collateral consequences. Incapacitation was present during the 1960s and the 1970s, which was a movement to cater to angry, law-abiding people in all neighborhoods, and perhaps most of all in poor neighborhoods where residents were most in danger of being victimized. So, in essence, this notion was a lot of upper-class, privileged individuals were looking around and seeing what was going on. This notion is called the broken windows theory if you're in sociology. And the broken windows theory contends we're going to allow police power. And we're going to expand police power through integrated police forcing. And we are going to allow police to go into different communities. And we are going to allow the police officer to, when they find these issues, to just brutally take care of those issues at whatever expense. It doesn't matter if people are going to jail and being stigmatized based on their status. It doesn't matter if people are going to go to prison for the rest of their life. They're solely being stigmatized because that cop thinks You did the crime, you should do the time, and you should be punished for it. And in society in the 60s and 70s, that's what people were saying. That's what Richard Nixon was trying to get in a Southern Strategy in 1972. Like, the more you study this stuff, the more you start seeing how the era of mass imprisonment was evil from the beginnings, from its inception. The National Research Council Committee determined 4 different elements. We have proportionality, parsimony, citizenship, social justice. Proportionality contends that if you commit a crime, the punishment to that crime needs to fit what crime you have committed. Parsimony contends that the period of confinement should be sufficient, not necessarily adequate, but sufficient, and should be no greater than necessary than to achieve the goals of the sentencing policy. Citizenship contends that the conditions and consequences of imprisonment should not be so severe or lasting as to violate one's fundamental status as a member of society. This is the concept also known as integration, where if you are arrested for an offense, for example, you should not be portrayed as being this criminal in society that only wants to just be released and keep committing more crimes. You are a citizen of the society. You are a person who's in the society. You are what makes up the people that are being protected against. So if you deviate away from those norms, the government needs to provide you with those means to be able to, those means and those resources to be able to reintegrate you back into society. Because that's what the purpose of the criminal justice system should be, is reintegration, not retribution. Social justice focuses on the fair distribution of rights, resources, and opportunities, and you are not supposed to undermine society's aspiration for those fair distribution of rights. What is criminal punishment? Well, in essence, there are 4 categories to what criminal punishment is. They have to inflict pain or unpleasant consequences. That's what punishment is in general. You got to inflict some sort of pain or unpleasant consequences. Then you need to be punished based on a statute. You have to prescribe a punishment in the same law that defines that specific crime. They have to be administered intentionally, and the state has to administer them. If the state does not administer them, it's not criminal punishment. That's the key. The 4th one is a necessary, not a sufficient element. That is a necessary element. Also, be aware that retributionists only want punishment. They only want to inflict pain so that criminals can pay for their punishment. Preventionists want to focus on what the greater good is, usually prevention or at least the reduction of future crime in general. Those are the key differences you need to remember. Okay, so retributionist appears in many texts of religion. Christianity has retribution examples. The Muslim faith has retribution examples. Judaism has retribution examples. They also have utilitarian examples too. So I'm not saying religion's good or bad. What I'm saying is the elements of retribution through the concepts of justice and culpability have been derived from religion. Retribution looks back to past crimes and punishes individuals for committing them because it is right to hurt them because they are culpable. You see what I'm saying? But remember, they can only be blamed if they are culpable. That's the point of serving justice. It's a part of making sure that the blameworthiness is met. So utilitarianism is broken up into 3 different specific categories. You have deterrence, which is then broken up into 2 subcategories. General deterrence, where we are going to deter individuals for committing the crime. And then specific deterrence, where we want to dissuade criminal wannabes from committing those crimes. We have incapacitation, where the crime you did was so odious that you need to be locked up for it. Um, so think of that kind of like as like a subcategory of retribution. And then rehabilitation, which focuses on that criminals are basically sick. Criminals need their assistance. They need justice to be given to them. They need opportunities. And in society, we are going to give them to the criminal defendant or the inmate. Now, the theory of rehabilitation is focused based on two things: determinism, forces beyond offenders' controls, causes them to commit crimes, and also therapy by experts can change the offenders. So, in our society, we want to make sure that people are being convicted for the crimes as well as the right reasons. So this is where we start getting into what are the virtues that we should take a look at when enforcing justice. So that's what happens with this idea of preventionism and the looks of consequences. So hedonism contends that human beings will seek pleasure and avoid pain. Rationalism focuses on the idea that they will do the former, but they will also not need to rely on discretionary authority of individualized decision makers because we have laws in place. We don't need this informal discretion. Now, we can obviously tell that the utilitarians were wrong about this because we still have police and we still have prosecutors that limit that notion. We still have bureaucracies that also limit that notion. Hedonism, the natural law that human beings seek pleasure and avoid pain, another important factor that I just discussed. And classical deterrence theory determines whether punishment outweighs pleasure or underweighs pain, or underweighs pleasure, overweighs pain, etc. Principle of utility is based on the principle of parsimony and proportionality, to the extent that individuals are only allowed to be punished based on the minimum amount of pain necessary to prevent a future crime. It's also a limitation to the notion of specific deterrence as well. The text case method, I don't personally think is really that important. It's just this notion that in your textbook, you should pretty much just understand that it combines criminal law with case law. Just remember that. That's pretty much all you need to know about it. Now, what you do need to know about this is, what's a guilty verdict, what's a non-guilty verdict, what are trial courts, and what are appellate courts. A guilty verdict does not necessarily mean that you've done the crime. It just means that you're legally guilty. It means that the evidence that was introduced at trial was beyond a reasonable doubt, meets all the elements, meets all the standards, you know what I'm saying, is factual, and you're legally guilty. And a not guilty verdict doesn't mean you did not do the offense. It just means that the prosecution has failed to prove the case beyond a reasonable doubt. Where that's based on the notion of our society. It's better that 9 criminal defendants that did the offense get let free than for one person who did not do it to go to prison. That's the reason why we have this system, is to make sure that people are not going to prison unless they truly, truly, truly did something wrong where they need to definitely go to prison. You see why I did that? I did it intentionally because criminal defendants should not all be punished equally. if you committed a misdemeanor, for example, you should not be punished in the same way as someone who committed a felony. But they should all be treated equally and provided with due process and equal protection. Trial courts are what are called the courts of original instance. Appellate courts are your appellate court, intermediate court levels, and also your apex level courts. At the trial court levels, this is where evidence is introduced in court. This is where hearings are conducted. This is where trials take place. These are jury trials. This is where records are recorded. Bench trials also happen here. Appellate courts only focus on the legal question and the controversy when an appeal occurs. Okay, so now we're going to talk about parts of an individualized criminal case. Judgment. The court's judgment is how the court disposes of the case. An opinion is the point of the story. The court backs up its judgment by explaining how and why it applied the law to the facts of the case. Okay, so here's the thing. So we have our judgment, which is, all right, are you affirmed? Are you reversed? Are you remanded? How should the court's disposition be entered? So that's judgment. Now you have an opinion down here, which is based on, all right, what's really based on this judgment? So why did we rule what we did? And then we have two parts to that. So we have the holding, which is the rule itself. It's based on it. So, okay, so we held this because of this rule need to be applied based on stare decisis, or we created this rule and it should be applied. Or the doctrine of separations of powers already answers the question. Now, the court's reasoning explains, why did we make the rule if we did make a rule? What's the importance behind the rule? And now also know these. A majority opinion is the law of the case. A majority of justices agree on this. That's the outcome. It's final. Over. At the Supreme Court level. A concurring opinion is where they're agreeing with the majority, but they give different reasons for why they agree with the majority. Clarence Thomas has been doing this constantly with every single case, it seems, to go before the Supreme Court, unless the majority is so reactionary that he sides with them on those issues, and which it really doesn't make sense, because a lot of the stuff he's arguing is almost identical to what the conservative platform really wants. He just wants to put his views out there to explain why he thinks these certain laws should be in place. A plurality opinion, on the other hand, represents the greatest number of judges, but you don't quite ever get the majority. So, like, you might get 3 or 4 over here. Let's say you get 4. Then you might get 3. Then you might get 2. And you have to use what's called the Marx rule to explain, all right, so what really is the majority's opinion here? Don't use cases from plurality opinions if you get out in the line of work. And if you do, you better have a very compelling interest, and that better not be the most important argument that you're making, because a plurality opinion is very, very hard to explain to a judge and get a compelling agreement with. But if the case is 9-0 on the other hand, or 6-3 or 7-2, that's a lot easier and a lot more compelling to show the judge. Yeah, so just be aware of that. All right, so I think this wraps up the video for the majority of the content of the class. But just be aware to review the chapter summaries of the book, review your MindTap assignments for Chapter 1, and generally speaking, I hope you got something extrapolated from this video. Thank you all.